Good afternoon, everybody. My name is Michael Miscoe. I'm an attorney with Miscoe Health Law, and I'm happy to present this week's edition of the ChiroSecure Facebook Live presentation. And this week, we're going to talk about responding to requests for records from Medicare or commercial payers. I know we've done this in the past, but it's probably a topic that bears repeating every once in a while. So if you've heard it before, it won't hurt you to hear it again. The first thing, when you get a record request after the panic dies down, you don't need to jerk the wheel into a bridge abutment. The world as you know it is not going to end, but you do need to think about how you're going to respond, and you need not to waste time. Don't ignore it. It won't go away. But as you address these requests, be sure to first and foremost think about some HIPAA considerations. One, you have to analyze the carrier's request to make sure it complies with what's called the minimum necessary disclosure rule. Payers are famous for requesting the complete chart. And the problem with a request like that is your chart may contain things that they're not entitled to get. For example, if you do services that the patient pays entirely cash for, not because the service went to the deductible, but because it was a non-covered service and the patient paid for it, something like, say, for example, laser or decompression that they didn't cover. The patient may have executed, and if they didn't, I would certainly suggest that you do so, what's called a restriction on uses and disclosures, so that those records would never be discoverable for either payment or healthcare operations, which means to a payer. You also need to identify what records are pertinent to the patients or services or the time period that they're requesting. In some cases, a payer may request a particular date of service, and most doctors would provide the note for that date. But to the extent that medical necessity is on the table, and we won't know if they don't state the purpose of the request, which is one of the other things that we look at relative to the minimum necessary disclosure standards, is that the payer has to disclose the purpose of the request so that we know what records are pertinent and therefore can respond with the minimum amount of information necessary. They want the maximum amount of information necessary, and they want to provide as little information as possible, but we can A, buy time, and B, comply with HIPAA. Sometimes the answer to a record request is we draft a response asking them for more information. What is the purpose of your request, so we can comply with the minimum necessary disclosure standards and whatnot. We also look at the request to determine if it complies with any state statute of limitations period. Contractual provisions usually let them request anything they want. The limitations period comes into play later if they do a demand. So once we get the purpose of the request, then we look at what they're actually requesting. Like I said, if it's a specific date of service and medical necessity is part of their analysis, obviously we're going to need more than that one record to understand where that visit fits within the scope of a course of treatment. So you may need to go back and provide the initial exam and the treatment plan and maybe progress evaluations leading up to that visit, and maybe even some of the notes leading up to that visit in order for them to get a picture of what's going on with the care in that particular case. So look at that very carefully and don't just provide only what they're asking, or the dates that they're asking, provide all the records that are pertinent to those dates. We also have to look at, when you get a request, one of the first things that we analyze is whether you're getting the request from a payer that you participate with, meaning you have a contractual agreement. Usually those agreements require you to comply with their record requests. Or if you're a non-par provider, no such agreement exists, in which case we take an entirely different approach. So, participation has a very big impact as to how and or if we're going to respond. And when I say if we're going to respond, that doesn't mean if you're not participating, you can ignore it. But we certainly respond in a different way. Now, it's not uncommon for docs to, they pull the records and they start looking at them, and then they start having panic attacks about mistakes they made, things they omitted. And your natural reaction is to want to fix the records. Whatever you do, don't do it. Do not alter your original documentation ever, because you will take a case that's just about money and turn it into a Title 18 crime. And when I say Title 18 crime, that's the U.S. Crimes Code. It's in Title 18, and one of the potential crimes is false statements related to a healthcare matter, obstruction of justice, and the list goes on. So be very, 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 very cautious. Your records are what they are. If they don't say what they're supposed to say, there is a process that we go through to clarify, amend, and or correct the record, but it is an open and transparent process where we prepare either addendums, attestations that may further clarify the services that were performed. But whatever the issue is, this is where you're probably going to need some help getting those things drafted appropriately. We clearly identify the date that these addenda are created, and we let the payer know this is additional information that is provided in order to help them better understand what's going on. Now, they can choose to ignore that information or not. I don't care. All I care about is that we do the addendums, attestations the right way. We disclose when this information was created, and that the information that we provide is actually true. Organization of your records. Do not think that, oh, you're so annoyed by them subjecting you to an audit, you're going to make life miserable for them by not organizing your records. They should be in ascending date order. Any attestations, addendums, whatever, should be at the top. Cover letter on the top packet, but each patient alphabetical order, ascending date order for the records, and try to organize them in a way that makes it easy for the carrier to get through them. Because look, the easier you make their job, the more likely it is that they're A, going to like you, and B, find what they need to find. If you send them a mess and they can't find it, they deny the service, and then we get to appeal, and now we're in the position of having to change their mind. And that's sometimes very difficult. So make sure that your records are well organized. Also, once you get your records organized, make a complete copy of what you send them. First and foremost, counsel's going to need it for their experts at the time of an appeal. And we need to be sure that we get the exact duplicate of what they got, so that if there's anything extra that needs to go in response to some issues that they've identified, then that information can be delineated. And finally, we need to talk a little bit about when you should involve counsel. Now, in my experience, involving counsel early is a very important thing to do, not because I'm a lawyer and I get to make more money, but because it keeps you from making mistakes and potentially gives us an opportunity to address some issues that they're likely going to be raised, with addendums, attestations, or additional record information. But validating that we have a packet that hopefully addresses most of the obvious and easy concerns, like, did you sign your records? And we should make a comment about that. If your records are not electronically signed in your EMR, meaning it puts a statement in there electronically signed by Joe Smith, DC, then you're going to have to physically sign them and then print your name underneath with your credentials. And payers will deny over signatures, even though most do not have policies that even require them. And interestingly enough, they look for signatures for signature's sake without understanding what the signature actually means. The signature is an attestation that the information contained in the record is true. And oftentimes they'll fully happy with a signature over top of a physician statement says dictated, not read. Well, how could the physician attest that the record is accurate if he didn't read it or she didn't read it? So that's the importance of the signature. Most payers don't understand it. They're looking for signatures for signature's sake, but that's another easy thing that we can fix with counsel involved early on. If you're non-participating, counsel is especially critical because, in many cases, we will look at the risk of sending the records and giving the payer the opportunity to evaluate them rather than responding to the record request with an objection on the basis that they have no authority to audit you. I mean, they can ask to audit you, but you have no obligation to participate in that process. So there's a number of legal doctrines, but there's some potential blowback. So those are things that you'll want to discuss early so that you fully understand what your options are, and then you can instruct counsel how you want to proceed. If you're participating, you're going to have to respond. But again, the value of counsel early on is making sure that you understand your contractual obligations, what kind of time frames, if we need extensions, you got diminished staff because of COVID, whatever the issue is, they can work through that process. And no, payers don't go, oh my God, you got a lawyer, it must be a crook. That's not what they think. They're used to this. I do this 365 days a year, and payers sometimes appreciate when counsel's involved because they know that the process is going to be done correctly. I'm thinking that's probably pretty much all the time we have today. Next week, I think I saw on the screen, our speaker is Yvette Noel. I'm sure she's going to have a fascinating topic for you, and I'll look forward to seeing you next time.